Today, I want to give you an introduction to trade secrets, and then I plan to follow up with another video addressing certain specific topics, such as suggested protection measures and proving misappropriation. Before heading into the trade secret weeds, though, I want to take a moment to look at the big picture and remember where we have come from and where we are heading. So, we have completed our review of patents. Now we're going to move on to the other pieces of the IP puzzle and see how they may fit together to help your business. First, we're going to consider trade secrets. Then we will move on to copyrights, and finally trademarks. When we are done, you will have your hands around the full spectrum of potential intellectual property rights. At the end of the day, as an inventor or a business manager, you're going to have to determine the kinds of IP protection that might be appropriate for different types of innovations at various stages of development. So it's always a good idea to step back and reflect on the purposes, advantages, and disadvantages of one system of IP protection versus another. With this in mind, this is a good time to begin thinking about the pros and cons of choosing patent protection versus trade secrets. And to this end, I have listed several parameters which may help guide your decisions. Let's think about how the stage of development might matter. You know, when you first get started, you will formulate some ideas that seem promising, and then you will have to tinker with them to come up with something tangible that actually works. At this stage, patents are not going to help you. Really, all you have are some basic notions about what the invention might someday entail. You don't know enough to instruct someone how to make it. You can't even make it yourself. So you're not ready to file a patent application, even if you someday may want one. Thus, between patents and trade secrets, your only choice at such an early stage of development will be trade secrets. Gosh, we just finished several days considering whether patents can even be used to protect certain processes and technologies. So we know that abstract ideas, discoveries, and natural relationships are all off limits. But then there are debates about computer programs, internet business methods, artificial intelligence, and biotechnology. We have seen that for these, too, patents may not always be the way to go. Trade secrets, on the other hand, can be used to protect almost anything. Ideas, discoveries, you name it, trade secrets can cover it. Databases, check. Abstract business methods, check. Customer lists, check. Even information that something doesn't work. Clearly, these can't be protected by patents, but they are all within the ambit of trade secrets. So recognize that trade secrets can protect a far wider swath of subject matter than can patents. The standards for protection are different too. So with patents, you're going to have to demonstrate that your invention is novel and non-obvious. And you have a pretty good feel for what that means. For trade secrets, the information must be secret and protected with reasonable security measures. Thus, if you want to share it with the public, then you should be thinking more about patents. Obviously, expense will be a driving variable in any of these decisions. You should already be a little afraid of how the costs will mount if you seek a patent, even if it's just in the United States. And if you head to other countries, then the costs can get particularly nasty. And this is not just to get patent rights. It may be expensive to defend and enforce those rights as well. Thus, you may initially think, I don't want to go down the patent route. I don't have the money or the budget. So I'll just keep it secret. That has to cost less. Well, maybe. Initially, yes, trade secrets will often be cheaper. But if you look more long-term and consider the cumbersome steps that may be necessary to prevent others from learning the secret, then it may very well be cheaper to simply pay the money up front to get the patent. So I don't want you to rest with a typical knee-jerk reaction that the trade secret option is definitely less expensive. Related to this, you also need to consider how hard it will be to maintain the secrecy of your valuable information. You know, if you're going to sell an invention and thereby allow anyone to see how it works, then you are probably going to be disappointed if you rely on trade secrets for protection. Now, maybe you can disguise the secret ingredient or encrypt the information, but who knows how effective those measures will be. And here's one other thing about secrets. You're going to have to share them with others involved with your business. And so if there's any weak link that allows this secret to be divulged, then you're going to have to scramble to maintain control. I often like to think of trade secret protection as an inflated balloon. You know, when there's even just a little pinhole leak, then you may have to react immediately, or the air will just bust out all over the place, and then your secret is gone. It's just gone. With trade secrets, you have to be constantly vigilant, especially in the internet age. You know, all you need is one disgruntled employee to post your information on the web and bang, it just spreads like in the blink of an eye. And yes, you may have recourse against this employee, but come on, they're not going to have the money to compensate you for what you just lost. Now, there are risks with both patents and trade secrets, and I have alluded to some of them already. I'll just reiterate one for each here. With patents, the bargain one makes for protection is fully disclosing the invention to the public. The deal basically is, here's all you need to know about my invention, but I'm the only one who gets to do it for quite a while. But there's always the risk that you won't get the patent after the PTO publishes the application, or you lose protection, such as through litigation or inter partes review. In either case, you then face disclosure without protection. With trade secrets, the risk is that you lose control of the information and the secret gets out, perhaps due to carelessness, espionage, or a disgruntled employee. And so you have to weigh several factors, such as the type of secret, its value, the ease of protection, and the likelihood of receiving compensation, to address the very real risks from disclosure with trade secrets. I put the next item, company culture, on the list because when you are relying on trade secret protection, then everybody who comes into contact with your secrets has to buy into the importance of secrecy. To ensure this, you have to build a culture where your employees value secrecy and want to participate in the efforts to preserve it. So Apple, for the most part, has succeeded in building such a reputation. And its employees take pride in the positive distinction that secrecy brings to the company. However, Apple worked hard to build this culture, a feat that is not always so easy, like in Silicon Valley. So, some of you may have been into computers and programming for a very long time, or you know someone who has been. Thus, I think you recognize that we are talking about smart, creative thinkers who like to try stuff and share results with their peers. Well, these are often the same people that software businesses want to hire for their creative energy and programming skills. But then managers may run into resistance when they try to impose trade secret requirements on such freewheeling personalities. So I just want to alert you to this possible managerial challenge when you go down the trade secret path. The last two items are related to timing issues. With patents, you know that it typically takes around 3 years for the PTO to examine your patent application and grant protection. In the interim, while waiting, you have basically nothing. Thus, if you think that your invention has a market life of 3 years or less, then it doesn't really make any sense to go for a patent because by the time you get it, your technology will be obsolete. Trade secret protection, in comparison, can begin immediately. All you have to do is keep it secret and protect it accordingly. Thus, trade secrets would probably be the better option in this circumstance. The last item, the length of protection, is typically not a big deal. Patents last for 20 years from the filing date, which is usually more than enough time given the rapid pace of technological advancements. Trade secrets, though, can theoretically last forever, for as long as you can successfully keep the information secret. Thus, if you have a special formula for, let's say, an effective gas additive, and you think it might be valuable for more than 20 years, then pursuing trade secret rights might be advantageous. This next slide indicates where trade secret policies come from. Until somewhat recently, trade secrets were based solely on laws developed at the state level, unlike patents, which are founded on a federal statute. Thus, California has its own trade secret laws, and Oregon has its trade secret laws, and Texas has its own version. At first, these had some meaningful differences, but thankfully, almost all the states have now passed legislation modeled on a suggested format called the Uniform Trade Secrets Act. In fact, 49 out of 50 states, as well as Washington, D.C., have done so. New York is now the only holdout. In New York, trade secret policies derive from what we call the common law, and the principles are outlined in a document called the Restatement of Unfair Competition. The restatement, by the way, is basically a summary of decisions made by judges in trade secret cases over the course of history. To be honest, I don't really care that you know about this. In this course, we are going to address the Uniform Act, which is specifically relevant to California and every other state besides New York. So, if you happen to end up in New York, the terminology used to address trade secrets might be a little bit different. But I can assure you that the guiding philosophy and result will almost certainly be the same. Oh, here's one interesting thing I can show you right off the bat about the Uniform Trade Secrets Act. Here it is. Here's the whole thing on this page here, and about 1/3 of this page on the back. It's about 3 short columns long. That's it. In contrast, the Patent Act has over 200 sections and spans over a far larger number of pages. The reason is that patents are governed by very strict standards and principles. Trade secrets, on the other hand, are based more on gut feelings about right and wrong, and it doesn't take a lot of verbiage for people to recognize the differences. Okay, for completeness, I also want to inform you that there are now 2 federal laws that also govern trade secrets. The first is the Economic Espionage Act, and as the name implies, it is concerned mostly with foreign governments that engage in espionage to steal valuable technological secrets from U.S. companies. Violation can be a felony and potentially carries long criminal sentences and large fines. But cases can only be brought by the Justice Department, and it doesn't use the law all that often. The other federal law was passed more recently, in 2016, and could prove to be more important in the long run because private companies can sue for violations. For all intents and purposes, the Defend Trade Secrets Act is virtually the same as the Uniform Trade Secrets Act, and so it simply provides a way for litigants to sue in federal court in appropriate circumstances. There may be strategic litigation reasons to do so, and it could assist with enforcement. Anyway, these are things that are more important for your lawyer to grasp. All you really need to know here is that the same guiding principles govern state and federal trade secret laws. On this next slide, I have broken down the definition of a trade secret under the Uniform Trade Secrets Act. The first element is information, and the sky is the limit regarding what qualifies. It can be a formula, process, program, technique, customer list, knowledge about what works or doesn't work, you name it. So, whereas patents have limitations on appropriate subject matter, trade secrets have unrestricted breadth. The next criterion is that the information has value essentially because you know it and others who are versed with the technology do not. In simple terms, the secrecy of the information gives you an economic advantage. Thus, the focus is not whether the average Joe knows the information, but whether those in the field who might be competitors recognize it. Also, the information won't have value if competitors could easily learn it from public sources. The final item usually proves to be the most important, really because the first two elements are typically so easy to satisfy. What we are looking for here is whether you protected the information with reasonable security measures. The basic notion is that you should not expect the law to assist you with protecting your trade secrets if you don't treat them as something you value yourself. Thus, whenever you sue somebody for taking your trade secrets, they will argue that a reasonable person would have done more to protect the secrecy of something that you say is so valuable. And if they are persuasive, then you will lose. So you really need to pay close attention to your security measures. Of course, you don't want to lose control of your secrets in the first place. But if you do, then you would like to have a shot at compensation. Now that you know what a trade secret is, we need to address how someone might violate your rights. According to the Uniform Trade Secrets Act, the offense is misappropriation of the trade secret. What is misappropriation? Well, let's consider it first in general terms. I would like you to think of an individual who misappropriates as a bad person who knows what they are doing is wrong, and they do it anyway. As one example, let's say I have an employee and I tell him what the secrets are, and I instruct him to only use them for my business and not to tell others. So what does he do? He discloses them to a friend who works for a competitor. What a bad guy! He knows what the secrets are. He knows that he's supposed to keep them confidential. He promised me that he would not tell others, and then he violated my trust. Bad dog! All right. So I just decided I wanted to stand up and stretch my legs a little bit, and I hope that transition wasn't too awkward. I have this video camera that sort of self-adjusts or something, and it doesn't always do what I want it to do. So anyway, I said bad dog there because it makes me think of my father and others who don't know how to raise dogs. So just a little bit about me. My wife and I have lived with golden retrievers for over 30 years. We've often had two. We once had three. Some have been rescues, and others we have raised as little puppies. Anyway, in my opinion, golden retrievers just rule. But um, anyway, I want to step back a little bit and tell you a story about my parents. So, neither of my parents knew much of anything about raising pets. Frankly, my mom was afraid of animals and didn't want any kind of animal near her. But they were good parents. And when I was around 7, I said I wanted a dog, and they relented and brought one into our family. So they let me pick the breed, and I read a book that said that beagles are nice dogs. All right, beagles are terrific, but I'm going to tell you, I don't necessarily recommend them in urban areas because they like to chase cars. Oh well, that's a different story. All right, so we picked up a 7-week-old puppy beagle, and the breeder had already named him Wrinkles because he had these little wrinkles on his nose, and that name actually stuck with me. It's a really cool name for a dog, Wrinkles. Now, my parents were pretty clueless how to raise a dog. Look, there it goes again. And I certainly had no idea. I like that better. The lights aren't showing. Um, so anyway, I have this memory of Wrinkles. Um, he was a really cute puppy, by the way. Um, so my dad was reading the Washington Post in his favorite chair. And Wrinkles then walked by past Dad's chair, and he heads to the fireplace where there's a really sort of a nice rug on the floor. And so then Wrinkles squats and does his business. He pills right there on the rug. I think piddle is the right word for a video like this. Anyway, you know what I mean. Um, well, my dad looks up and he sees what Wrinkles has done. And I'm telling you then, so that he rolls up his newspaper and he jumps to his feet and he says, "Wrinkles, come here." And Wrinkles gets all alert and wiggly and he approaches my dad. And when he gets close, my dad bends over basically and takes that newspaper and whack! He hits him in the rear with a newspaper and he shouts, "Bad dog!" All right. Well, here we go again. Don't do that. I have a couple of comments about this. First of all, Wrinkles is not a bad dog. Wrinkles had no idea that the fireplace or the rug in the fireplace was off limits. From the day he was born, he has taken care of business wherever he has had the urge, and nobody has ever told him otherwise or to do otherwise. It's only a natural thing for him to do. Now, my father calls him a bad dog. A bad dog? He did something that he assumed was perfectly acceptable. How is he to know? If you ask me, I think Wrinkles has been falsely accused. I'll tell you something else. Wrinkles is now a confused dog. Why did this big man get so angry? Let's see. He called me and I came to him, and then he yelled at me and whacked me. You know what? The next time he says come, I'm going to run the other way. That must be what he wants. So I think you can see that this was not a very instructive lesson for Wrinkles. Now, if you want to handle this issue properly, then you should first inform Wrinkles what items are special in the house and what you would like him to do or not do with them. In this case, the rug is special, and you don't want him to piddle on it. The same, by the way, goes for trade secrets. You have to identify what items are special and that you don't want your employees to disclose them. All right, so getting back to wrinkles, you will have to let him know that other things are special too, like maybe all the flooring in the house. And for some items, he may have particular responsibilities. For instance, Wrinkles can sleep on the couch but can't piddle on it. Or maybe he can sleep on the rug but not come up on the couch. You get it. You have to inform him what's special and what obligations he has. Until he understands these things, he's not a bad dog for not behaving as you wish. He's just uninformed. Given this, here's how we should have handled Wrinkles in this situation. The best thing would have been to catch him in the act of piddling on the rug. Remember, he doesn't know that this is wrong. So don't call him a bad dog. Instead, just scoop him up and tell him in a stern voice, "No." By the way, he's going to stop piddling when you do that, just from the shock of you grabbing him like that. So then what you need to do is take him quickly outside where you would like him to go, put him down, like in that special place in the yard or wherever, that place in the yard you'd like him to go, or just generally outside. So put him down there and wait, because if all went well, he hasn't finished doing his business yet. And so hopefully he will then soon piddle again, now outside. And when he does, you're just like all full of praise. Good dog, Wrinkles. And, I would give him a puppy treat too. When you're raising a puppy, you should always have like a few treats in your pocket. All right, so now you've begun to set the ground rules. Inside is bad, outside is good. And so anyway, he's gonna do it wrong a few more times before he understands that inside is a special place and he shouldn't fiddle there. So I would plan on repeating this for a little while, but he's gonna get it in due time. It really doesn't take very long. So anyway, after a while, this is going to become routine. He clearly gets it. Now, imagine if one day he just stands on the rug, looks you in the eye, and for no reason defiantly lifts his legs. I've actually never known a dog to actually do this without good cause. But presuming he just piddled to break the rules and defy you, then I would agree at that point that he's acting like a bad dog. I mean, he knows the difference between right and wrong, and he purposely chose to do wrong. Bad dog! So, I hope you can kind of see the parallels that this has with handling trade secrets. It definitely helps me to think of misappropriation in terms of bad dogism. Honestly, all you need to do here is determine if you think the accused acted like a bad dog. Should he have been aware of the secrets? Did he understand how he was supposed to handle them? And did he knowingly do otherwise? Okay. I'm back in my chair. On this slide, I put a couple of characteristics that associates trade secret misappropriation with being a bad dog. Okay, look, if you are breaking and entering or using surreptitious listening devices, then you already know that what you're doing is wrong. That explains the first bullet, which lists behaviors such as theft and espionage to be acts of a bad dog. Similarly, if you promise someone you won't do certain things, or you just know from the circumstances that you're not supposed to do them, then you are a bad dog for violating their trust. Again, you know that what you're doing is wrong. Let me reiterate the overall theme about misappropriation. You must have a reasonable awareness of the trade secrets and how you're supposed to handle them. And then you violate your obligations. Bad dog, just like wrinkles. Now I want you to consider the next bullet. It basically suggests that if you work with a bad dog, and you're aware that he is engaged in bad behavior, then you're like a co-conspirator in his bad dogism, and you should be treated accordingly. Bad dog! And finally, I notice on this slide that reverse engineering is typically not considered bad behavior under trade secret policies. Some statutes, such as the one adopted in California, specifically say so, but it's the general rule anyway. I said typically because the presumption is that the person who is tearing the product apart acquired it in a lawful fashion. Otherwise, they may be a bad dog from the very start. Also, if you promised that you would not reverse engineer, then you could be a bad dog for breaking that promise. We're going to see later how this may be relevant, such as with computer programs. Here, on this next slide, I listed the behaviors that the Uniform Trade Secrets Act defines as misappropriation. I actually left one out because it's a little more convoluted. Anyway, I think you'll be able to see how they all fit into the notion of a bad dog. We start with acquisition by improper means. The Act defines improper means as things like theft, espionage, and fraud. So they are behaviors that you just know are wrong. Inducing disclosure falls into the same camp. It's like paying somebody to wrongfully tell you the secrets. The next one says disclosure or use, when you are reasonably aware that such actions would breach your fiduciary duties to not use the information or maintain its secrecy. I then put in red my interpretation of this in simpler terms. Basically, this means that I promised or otherwise knew that I shouldn't use the information or tell others about it. And then I did. In other words, I knew my obligations and I violated them. Bad dog! For this, think about an Apple employee who tells company secrets to an internet blogger, or one who leaves the company and then uses Apple's secrets at his next job or in his new startup. The next item refers to the situation where I received the information from someone who I know did something bad to get it, like stealing it, and then I have the nerve to use the information myself or tell others about it. Think co-conspirator in bad dogism. And the last item here is of the same nature. I received the information from someone who I know had promised to keep it confidential, but I nevertheless used the information for my own benefit, or I disclosed it to others. Again, we're talking about a co-conspirator with a bad dog. Now, I want you to think about an employee that switches jobs and wrongfully brings trade secrets with him. He then uses the trade secrets to advance projects with the new employer. When the former employer becomes suspicious, it will probably charge the ex-employee for misappropriation, for violating the confidentiality agreement. And that may not be hard to prove. However, it will probably want to nail the new company and its managers as well. So, what do you think? Are they bad dogs? What if they didn't want the new employee to use trade secrets and had no idea what he was doing? They just hired him because he was naturally talented. That doesn't sound so bad to me. On the other hand, if they hired the employee to gain quick access to those secrets, then that's a different ballgame. Okay, let's not beat this dead horse any longer. I think you get the idea. This all comes down to your general sense of right and wrong, and ultimately your gut feel about fairness will usually lead you to the right answer. That's the beauty of trade secrets. And that sounds like the right note to wrap this video up.